Something just changed that millions of gun owners still do not know about. A federal court issued an emergency ruling that could fundamentally alter how concealed carry permits work across the entire country. If you own a firearm or care about your right to protect yourself and your family, what happened in the last few weeks could affect you in ways most people are only beginning to understand. By the time most people realize what happened, they may have already lost a protection they did not even know they needed. That is the real danger here, and that is why this video matters right now. The situation centers on a Supreme Court decision from 2022 known as the Bruen ruling. That case struck down a New York law that required people to prove they had a special need to carry a concealed weapon in public. Before that ruling, states could essentially decide who was worthy of a permit and who was not. The court said that was unconstitutional. The Second Amendment protects an individual's right to carry a handgun for self-defense outside the home. That was a landmark ruling that changed everything for gun owners in states with strict may-issue policies. But here is where things get complicated, and this is where most people stop paying attention. States did not simply accept the new reality. Many found new ways to restrict where legal gun owners could carry their weapons. Hawaii and Maryland are perfect examples. After Bruen, these states passed laws limiting where someone with a concealed carry permit could bring their firearm. Hawaii said you cannot bring your gun into restaurants that serve alcohol, banks, or parks unless the property owner explicitly says it is okay. Maryland went further, restricting guns in government buildings, public transit, schools, hospitals, and locations within 1,000 feet of any public demonstration. These were not minor adjustments. They were systematic attempts to make legal concealed carry practically useless in public spaces. If this information is useful to you, hit the like button and consider subscribing. We work hard to break down legal changes that affect your life and explain them in language anyone can understand. This created what legal experts call a circuit split. Different federal courts were reaching different conclusions about the same constitutional question. The Second Circuit struck down similar restrictions in Antoniuk v. James, but the Ninth Circuit upheld Hawaii's restrictions. Meanwhile, the Fourth Circuit struck down part of Maryland's law but upheld the rest. This conflict meant the same constitutional right could mean completely different things depending on which state you lived in. That is exactly the kind of situation that demands a final answer from the highest court in the land. The Supreme Court decided to take up one of these cases. The case is called Wolford v. Lopez, and it comes from Hawaii. The court heard arguments in January 2026, and a decision is expected by late June 2026. But the emergency rulings that have people talking happened even more recently. When cases are pending, courts can issue stays that pause the enforcement of lower court rulings while the higher court figures out what to do. Those emergency applications and rulings have significant implications for how states can enforce their gun laws while these constitutional questions are being sorted out. What makes this so urgent is that the implications ripple far beyond Hawaii. When the Supreme Court agrees to hear a case like this, the entire country waits for an answer that will reshape gun rights for years to come. But in the meantime, states are operating under their own rules, and those rules can change quickly. Gun owners who thought they understood their rights may discover that the places where they thought they could legally carry are suddenly off limits. And ordinary people who went through the process of getting a permit, who paid the fees, who completed the training, who passed background checks, are left wondering whether all of that actually protects them in the situations that matter most. Let me paint a picture of what this looks like in real life. You live in a state with strict gun laws. You completed your training, you got your permit, you followed every rule. You go to a restaurant for dinner with your family. You are armed because you believe in taking responsibility for your own safety. Halfway through your meal, you realize your firearm is technically not allowed because the state passed a law after Bruen saying restaurants that serve alcohol are sensitive places where concealed carry is prohibited. You simply walked in, sat down, and started eating dinner. Now you are breaking the law without knowing it. And if something goes wrong in that restaurant, you are the one facing criminal charges, even though you did everything right according to the rules that existed when you got your permit. This is not a hypothetical. This is the reality for thousands of law-abiding gun owners right now. The rules changed after they earned their permits, and they did not get a notification. They did not get a reminder. They simply woke up one day to find that the thing they thought was legal might no longer be legal in the same way. The dangerous part is that ignorance of the law is not a defense. If you are caught carrying your firearm in a place quietly added to the list of sensitive places, you could face serious criminal charges even though you had no idea you were doing anything wrong. Subscribe now and turn on notifications so you do not miss future updates on situations like this one. These legal developments change fast, and the only way to stay ahead of them is to have a source you can rely on for accurate, timely information. What the Supreme Court is trying to figure out is whether states can keep adding places to that list indefinitely. Can they declare entire categories of locations off limits to legal gun owners? Can they effectively gut the Second Amendment right outside the home by making it impractical to exercise anywhere in public? The answer will determine what the right to bear arms actually means for the next generation of Americans. But until that answer comes, there is a gray zone that creates real danger for real people. One of the most striking things about the recent legal arguments is how the justices themselves described some of these state laws. During the Hawaii case arguments, one justice used the term vampire rule to describe a law requiring gun owners to get explicit permission from property owners before entering public spaces with a firearm. The comparison was to vampires needing an invitation before entering a home. The justice was pointing out the absurdity of requiring gun owners to announce themselves and get permission to exercise their constitutional rights in places open to the general public. A bank, a restaurant, a park, these are not private homes. They are spaces where anyone can walk in and conduct business. Yet, under some of these state laws, you would need explicit consent of the property owner to exercise your Second Amendment right inside those spaces. The historical argument being made by the states is also worth understanding because it lies at the heart of the legal debate. After Bruin, the Supreme Court established that any gun regulation must be consistent with this nation's history and tradition. That means the government cannot just ban guns wherever it wants. States like Hawaii and Maryland have tried to argue that their modern sensitive places restrictions are rooted in historical traditions. But the courts are scrutinizing those historical claims carefully, and in some cases, the historical laws being cited are not exactly flattering. One justice pointedly asked how a Reconstruction-era law specifically designed to suppress the rights of newly freed Black Americans could serve as the foundation for modern gun restrictions that affect all citizens. That question cut to the heart of the matter. Historical laws that were used to discriminate cannot simply be recycled to justify contemporary restrictions on constitutional rights. Here is what nobody tells you about this situation. The people most affected by these rulings are not criminals. Criminals do not go through the permit process. Criminals do not complete the training. Criminals do not submit to background checks. The people most affected are ordinary citizens who decided to follow the law, who invested their time and money into becoming legal gun owners, and who are now caught in a legal crossfire between state governments trying to restrict gun rights and federal courts, trying to determine where the constitutional limits are. If you are watching this and thinking this does not apply to you because you do not live in one of those states, consider this. These legal battles are happening at the federal level, and the decisions being made right now will set precedents that affect every state in the country. What the Supreme Court decides in the coming months will either expand the ability of states to restrict concealed carry or limit that ability and return power to gun owners across the country. The outcome is not predetermined. The justices are genuinely divided on these questions, and this is not a situation where the result is obvious. That means it is more important than ever to pay attention and understand what is at stake. The states pushing these restrictions hardest are not necessarily the states with the highest crime rates. Many are states where the political leadership has a particular agenda regarding firearms, and they are using the legal uncertainty created by Bruin as an opportunity to test how far they can go in restricting gun rights before the courts step in. Hawaii passed Act 52 specifically to respond to Bruin. Maryland passed its law specifically to respond to Bruin. These were not spontaneous reactions to public safety data. They were calculated responses to a Supreme Court decision that the political leadership disagreed with, designed to see how much of the Second Amendment they could effectively eliminate through creative legislation. Emergency stays are not permanent solutions. They are temporary pauses while the courts figure out the bigger questions. But in that temporary pause, lives can be changed. People can be arrested. Permits can be invalidated. The temporary nature of these rulings does not make them less urgent. If anything, it makes them more urgent because the situation can change again at any moment. Here is the most important thing I want you to understand. None of this is meant to make you afraid. It is meant to make you informed. Fear without knowledge is paralyzing. Fear with knowledge is empowering. You now know what is happening. The legal landscape is shifting. Emergency rulings and stays are being issued. The Supreme Court is on the verge of a major decision. And the people most affected by these changes are ordinary citizens who followed the rules and now find themselves in legal uncertainty through no fault of their own. What you do with that knowledge is up to you. You can ignore it and hope it does not affect you. You can learn more about the specific laws in your state. You can talk to a legal professional who specializes in firearms law. Or you can share this information with someone you know who might be affected and who might not yet be aware of what is happening. That last option matters more than you might think. Most people impacted by these changes will not hear about them in time to do anything about it. They will find out after the fact when the damage is already done. If you found this video valuable, please share it with someone who needs to hear this. Hit the like button if this content is worth sharing. When you like a video, it helps more people see it. It signals to the platform that information like this deserves to reach the people who need it most. The bottom line is this. Something important is happening in the courts right now. Emergency rulings are being issued. Constitutional questions are being decided. And the outcome will affect the fundamental right of millions of Americans to protect themselves and their families. You deserve to know what is happening. You deserve to understand the stakes. And you deserve to have the information you need to make smart decisions about your own safety and your own legal exposure. The Supreme Court will issue its ruling on Woolford v. Lopez by late June 2026. That ruling will either confirm that states cannot use sensitive places restrictions to effectively eliminate the right to carry firearms in public, or it will open the door to even more restrictions. Either way, it will not be the end of the story. These legal battles will continue. New challenges will arise. The landscape will keep shifting. And the only thing you can count on is that staying informed is your best protection against being caught off guard. Do not let this information sit idle. If you own a firearm, check the laws in your state and keep checking them. If you have a concealed carry permit, understand exactly what it protects and where it does not protect you. If you are considering getting a permit, talk to someone who can give you current, accurate information about what the legal situation looks like right now and what it might look like by the time you finish the process. The law is not static. It is moving, and if you are standing still, you are falling behind. Before you go, share this video with someone you care about. Maybe they own a firearm. Maybe they have a permit. Maybe they simply care about constitutional rights. Whatever the reason, sharing this video is one of the most effective things you can do to make sure the people you care about are not caught off guard by changes they did not see coming. The clock is ticking on some of these rulings. The Supreme Court decision is coming. The emergency stays will either be extended or lifted. And through it all, ordinary people who did everything right are the ones who stand to lose the most if they are not paying attention. Stay informed, stay alert, stay safe, and do not wait until it is too late to understand what is happening to your rights. The information in this video could be the difference between knowing your rights and losing them without even realizing it. That is not fear-mongering. That is just the reality of a legal situation changing faster than most people can keep up with. Keep watching, keep learning, and most importantly, keep protecting yourself and the people you love. If you want more content like this, make sure you subscribe and hit the notification bell so you never miss an important update. Your rights are worth staying informed about.